At the Global South Network, we are deeply committed to promoting interdisciplinary and cross-regional conversation. Our mission has always been to create an inclusive platform where judges, academics, lawyers, and civil society actors from across the Global South and beyond can exchange ideas, share good practices, and learn. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? You came upon a series of lush islands with white sands, beaches that are caressed by warm turquoise blue water. But what did they do? They enjoyed the bliss and exploited the people and land for their own benefit. For locals and for commentators from the global south in the Caribbean, colonized, first of course the indigenous, the first peoples, and then imported forced labor in our region, their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane, cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the sea and through the surf that these colonizers came in their boat, landed on the Caribbean's pristine sand beaches, turned their turquoise waters, their Caribbean seas red with the blood of so many innocents. However, not only were people and lands and resources colonized and exploited, and the point of today's talk is about fact and colonizations of our legal imagination has also been an enduring legacy of colonial history of Caribbean people. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imagination? Have we been developing a truly Caribbean jurisprudence? There can be no social jurisprudence separated from social context. And so social context is critical to this idea of a Caribbean jurisprudence.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provides a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Naumen Riad.
Dr. Naumen Riad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riyad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
Good morning, good evening to all joining us from different parts of the world. I am Dr. Noman Riayat, the Chief Convener of the Global South Network. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers. I would now like to open the floor to question and answer. First question for our Honourable guest speaker is: the Caribbean Court of Justice operates within a unique framework that balances regional integration under the Caribbean community system with national sovereignty. How does the Caribbean Court of Justice manage this delicate balance between respecting national constitutional identities and promoting regional uniformity in legal interpretation and governance across Caribbean community member states?
Yeah, I think that's an excellent question, and it's excellent because on the one hand, I have spoken using the metaphor of cuisine in the Caribbean. They are distinct flavors, and if we are therefore to use that idea of differences as natural as breathing, how does a court comprised of the same judges adjudicating both in regional and in territorial hearings balance what can become what I call the imperial magisterium to universalize the law, which in a very real sense the JCPC did with all of its territories, right? When it administered the law as the Judicial Council. How does the CCJ not fall into that model? And I think the answer lies in self-awareness. So that I think it is unrealistic to suggest that that cannot or will not happen, because you are sitting in these two capacities, but you're also sitting as the apex board for several jurisdictions, and so there can always be this tendency to want to universalize for consistency, predictability, and regional integration, have similar approaches. But I think there is enough wiggle room to have commonality with nuance. And I think that's actually a human rights thing, because we need to regard and respect the individual sovereignty of each nation state. Yeah. So regrettably, for whoever posed that question, there's not a straightforward answer, yes or no. And so I think it is a self-awareness of the court, and through that self-awareness, having the skills and the capacity to nuance their judgments. I hope that's helpful.
Thank you very much. Yes, it is helpful, and I'm sure they will find it very useful. The next question is from a PhD candidate, School of Law, University of Edinburgh, Amanullah Amazai, and he's thanking you very much for the informative presentation. And the question is about legal pluralism in the Caribbean region, which was mentioned in your presentation, and he wonders whether the CCJ deals with customary law and decisions of informal justice mechanisms. And he appreciates your thoughts on this, and in particular, he wonders whether the existence of different legal accounts, such as informal justice, is a sign of and because of the weakness of the state legal system.
And the simple answer to that is basically no. Unlike, for example, in Nigeria or North African states where you have coinciding, you have the national legal order, which is actually the sort of most hierarchically supreme sort of legal system. But you have within that, you have, say, Sharia law, which may deal with property and family. But then you also have customary and tribal law, which in Nigeria is recognized in the constitution, but in other North African states is actually not recognized formally, but acknowledged in the due process. And so within customary law or tribal law, in, for example, not in Nigeria, in other North African states or African states, that is, say, relating to marriage and succession and property, the courts pay certain deference to that, even though that is not formal. We do not have that in the Caribbean. That's not been our system. What we do have is a different sort of tension, which I explained. In St. Lucia, for example, there is a civil code. So that's a hybrid legal order between common law and civil law traditions, but not the customary law that I think the question is pointing to. And as I pointed in Guyana, you have Roman Dutch law because of colonial antecedents that informs, for example, the property law in Guyana. But again, that is that's not a customary legal order. Yeah.
Thank you. Next question is, in your lecture, you refer to the CCJ's developmental approach to constitutionalism, one that integrates legal interpretation with the pursuit of broader societal goals. Could you elaborate on how the CCJ conceptualizes developmental constitutionalism in practical terms, particularly in cases addressing socioeconomic rights, access to justice, or environmental sustainability?
Yeah, no, again, very, very good question. In the governance model that the written constitutions have brought into being, there is, again, there's this tension. There's a tension between the executive's responsibility, three branches of government model, executive responsibility to lead policy and also lead the legislative agenda in Parliament. The Parliament is supposed to be passing the laws, and in the classic British model, judges are not supposed to be saying a law is to be struck down. They're supposed to be interpreting and applying, in some senses, sometimes clarifying. All right. The model that has been developed in Caribbean constitutionalism is a model that is necessarily developmental with impact for society and social and economic policy. Why? Because when the executive brings forward a policy and embodies it in law, then the courts have a constitutional power and duty to, if it is found short of, for example, fundamental rights standards or separation of law standards or rule of law standards, to say to the executive and the legislature, well, you've missed the mark a little bit. You know, you overreached a little bit. And it's this the tyranny of the majority point, right? It's, you know, the French writer writing in, I think in 1835 about American constitutionalism, and the idea that even though democracy is about majority rule, well, the majority can constitute a sort of a tyranny of the minority, and the courts are the ones who must now stand in the breach, as it were, and hold the tension. So how does it negotiate it? In answer specifically to the question, it negotiates it through the lenses of constitutional core principles, values, and standards, including human rights standards, but not limited to human rights standards because of something called the basic deep structure doctrine, which says there are certain core constitutional principles which are inviolable: separation of powers. You can't get involved in sentencing, for example. Rule of law, which we kind of understand, the protection of the law, and so on. So that's how it negotiates that tension and space between these three branches of government. But the courts have the final arbiters, actually, of even socioeconomic policy.
Thank you very much. And last final question before we conclude the session. So the CCJ, like many regional courts, must constantly build public trust, to establish its legitimacy, especially given its relatively young institutional history? What strategies has the CCJ adopted to strengthen public confidence in its authority, and what role does transparency, outreach, and education play in shaping public perceptions of regional justice?
Yeah, again, these are Professor Rayad, excellent questions, very rich questions, each one of which we can spend a lot of time chatting about. First of all, the CCJ takes the approach that its core work is the hearing and determination of matters brought before the court, both in the original jurisdiction and in the appellate jurisdiction. And so its first strategy, if you want to call it that, for gaining public trust and confidence is the integrity, robustness, and transparency of its jurisprudence. And so, for better or for worse, and time alone will judge that, the CCJ's first priority is in the integrity, relevance, and relevance of its jurisprudence for Caribbean people. And that is something which a court can't judge for itself. People like yourself and others have to determine whether the jurisprudence is bringing legitimacy to the court. So that's one area. The second, and the question raises this, well, are there other areas? Basically, that's the question. What about judicial outreach, education? Absolutely. The CCJ from inception basically has evolved organs of the court, as it were, some formal, some less formal, which involve themselves regionally to try and develop and improve and contribute to the administration of justice in the region. So, for example, the court in its current strategic plan, which is about to change, has as a particular strategic goal improving regional justice sectors. So that's a strategic goal of the court. It does so in many ways. Formally, there is something called the Academy, the CCJ Academy for Law, run by senior judges of the court, and it intervenes when requested on a project basis by territories and elsewhere to assist in building up the administrative needs and so on. Very recently, the Academy for Law has initiated, coordinated, and completed something called the Needham Point Declaration, which is an overarching approach to trying to reform criminal justice in the whole region, because crime is a big problem in the region, and that has been well received and has been implemented. The court also has supported, I'm chair of the Caribbean Association of Judicial Officers, and that is an organization of judicial officers throughout the region. CCJ provides administrative and staff support for that CAJO, Caribbean Association of Judicial Officers. But the CAJO, for example, has researched and developed many instruments of practical utility. For example, a criminal bench for Guyana, Barbados, and Belize. We are completing, hopefully by the end of the year, another criminal bench book for Bahamas. We've done research into and developed guidelines for judiciaries to deal with persons with disabilities. We've developed approaches to improve procedural fairness, and so on and so on and so on. In fact, together with different international organizations, we've developed, researched and shared reports around dealing with First Peoples, indigenous peoples, tribal groups, and so on, access to justice. So through these, and I'm using two as illustrative, for example, through these two organizations, the Academy for Law and the Caribbean Association of Judicial Officers, the court supports them, and they work educationally and in outreach ways to fulfill strategic goal number 6, which is to develop regionally and strengthen regionally the administration of justice and the justice sector, and so on and so on. I could say a lot more about it, but I hope that gives a flavor of how the court responds in ways beyond its jurisprudence to help build, to be relevant, first of all, and therefore, consequentially, to build public trust and confidence in the court. Because yes, you are right, whoever posed the question, 20 years is a short time in the life of institutions such as a regional court.
Thank you very much, Honourable Justice Jamadar, for providing comprehensive answers to very rich questions, as rightly you mentioned. Okay, so as we come to the close of the today's Global South Network Judges Guest Lecture, it is my great pleasure and honor to extend heartfelt thanks to our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, for his illuminating and deeply enriching lecture. Justice Jamadar, your reflections have taken us far beyond the courtroom and into the very heart of what constitutionalism means for the peoples of the Caribbean and indeed for the wider Global South. Your exploration of how the Caribbean Court of Justice has approached constitutional interpretation in a way that is developmental, inclusive, and rooted in local realities reminds us that law is not static, it evolves with the society it serves. Your lecture have shown how constitutionalism can flourish not as an imported ideal, but as a living, breathing framework that grows out of shared history, regional cooperation, and a deep respect for justice and dignity. This message resonates profoundly across the Global South, where many societies are similarly seeking to reconcile inherited legal traditions with contemporary aspirations for equity, development, and self-determination. On behalf of the Global South Network, I thank you for sharing your wisdom and your experience and your passion for the transformative potential of constitutional law. I would also like to express gratitude to all our participants from Africa, Asia, Latin America, Europe, and beyond for joining this lecture. Your continued engagement gives a life to the network's mission, building bridges of knowledge and solidarity between the Global North and the Global South. At the Global South Network, we firmly believe that collaboration among judges, scholars, and practitioners across jurisdiction is not only desirable, it is essential. It enables us to learn from one another, to strengthen our institutions, and to advance a truly global conversation on justice, equality, and human dignity. Once again, Honourable Justice Jamadar, thank you for honoring us with your time and insight. We look forward to continuing this conversation and to welcoming you again in the future. And to everyone who joined us today, thank you for being part of this growing global community. Look after yourself. Have a wonderful day. Bye-bye.
Thank you very much. Bye-bye.